Miss Stark, I have a question.
What is it, Kyle?
When Hamlet calls Polonius a fishmonger, is he making fun of him?
What scene are you referring to?
Act 2, Scene 2. Isn't that the one we're supposed to be reading?
Oh, just a minute. Let me take a look. I have a better idea. Why don't you just go on reading, and then tomorrow when you come to class, we'll discuss that line.
Oh, okay.
Okay.
Hi, Dr. Richardson.
Good morning. Come on in. Nice to see you.
This is the third time I asked Mrs. Stark a question she couldn't answer.
I know. Did you see the look on her face? She looked really uncomfortable.
I already told my parents what a circus this class is. That she seems so unprepared with every Hamlet lesson so far. When I tell them this, my mom is definitely going to call the school.
Bridget Stark is a high school English teacher who is up for tenure. Her evaluation reports are generally positive as they relate to her teaching abilities. At the end of Year 1 and Year 2, she was cited for classroom management problems. In Year 3, she was not cited for classroom management problems, but she was cited for an instructional problem. She had failed to completely read Hamlet prior to discussing it with her class. The major continuing problem is Ms. Stark's failure to sign in and out of school. She is cited for this violation 12 times, including 5 times in Year 1, 4 times in Year 2, and 3 times in her third year. In the spring of her third year, she's called in for a meeting with the principal. The meeting is to discuss whether Mrs. Stark will be granted tenure.
Good morning, Bridget. Thank you for coming in. As you know, we're going to be talking about your annual performance report. Here's a copy of it.
Okay.
And I need to begin by telling you that we will not be recommending you for tenure this year.
What? Are you kidding me? This isn't right. I don't have a job next year. Oh, I get it. This is about my being Jewish, isn't it? And it's about the fact that I'm one of the older teachers here.
I assure you, Bridget, that this has nothing to do with your age. It has nothing to do with your religion. This is about deficiencies in your performance over the last 3 years.
I know I had some deficiencies Year 1 and 2 with my classroom management, but I didn't have any problems this year.
Other things have come up, and you're aware of these things. One thing is that there is a pattern in which you have not been prepared for instruction. One example of that is that you did not read Hamlet before you taught that unit.
I knew the story well. I read the teacher's guide, I saw the movie, and everything was going fine until one student happened to pick up on a line and go on and on about it, which was completely irrelevant to the discussion.
There's another major issue that you're very aware of, and that is you continue to disregard the school's protocol for how teachers should sign in and out. And you have been cited in writing on that 12 times in the last 3 years.
My classroom is on the opposite side of the building from the main office, and the exit to the faculty parking lot is right by my door. So sometimes I forget to sign in and out. But these are only minor problems. The real issue is that this district doesn't like older teachers, and it's predominantly Christian. Therefore, I feel as if I'm not being well respected because of my religion.
Bridget, I am highly offended that you would even suggest that a decision this important is based on anything other than your professional performance.
Well, I know what this is about, and you're going to hear from my attorney. Hello, Mr. Nash. I'm Bridget.
Mrs. Stark,
I spoke to you on the phone not too long ago. Nice to meet you.
it's a real pleasure to meet you, too.
I appreciate your taking time out of your schedule to speak to me.
Oh, please.
I've been very upset lately.
I can imagine. Please, have a seat.
Thank you.
So, Mrs. Stark, I know from your initial call you said that you were denied tenure and you feel that you were the victim of discrimination?
Yes, that's right. I believe that I have been a victim of both discrimination because of my age and because of my religious beliefs.
All right, we're going to discuss all of that, but first let's talk about your evaluations.
Well, they cited a couple of problems. One was in the area of classroom management,
Okay.
and also there was a citation about the fact that I didn't sign in and out of the school. But I looked into things a little further, and I've sort of done my homework for you.
Oh, I love when a client has done research for me. So.
Well, let me just show you what I have. I'll give you a copy first for your records.
Okay. So, what did you find?
I have a few statistics showing how this district has been discriminating against its teachers.
Interesting.
For example, in the last 5 years, 19 out of 20 new teachers under the age of 45 received tenure. However, only 1 of 4 teachers over the age of 45 received tenure. So to me, that age 45 is a district cutoff.
I'm going to take a closer look at this. I appreciate the fact that you did some research for me already on this. It seems like some pretty powerful evidence. What can you tell me about the evaluations of some of the other teachers?
Well, I have some evaluations here too. I have copies of evaluations from 3 of the teachers. They're actually my friends, all of whom received tenure. And what's interesting to note is they all got tenure, but on their evaluations there were 10 or 20 items marked as needs improvement. On my evaluation, I only had 1 or 2 items marked as needs improvement. But they all got tenure, and I was denied.
Wow. That's pretty powerful evidence. All right. I'm going to look closer at this, and we are going to review the possible claim. I also want to talk about the potential religious discrimination claim.
Well, to be quite honest, I am 1 of 2 Jewish teachers out of the 20 in our district.
Oh. And what makes you feel that you might have been the victim of discrimination based on religion?
Well, it's especially evident at Christmas time. As a matter of fact, the principal of the school cited me for being insensitive to the community when I complained about the hallway decorations they had at Christmas time.
So was there actually a Christmas display?
Yes, there was.
Did the display include any other religious items?
No, none.
And how did the principal respond when you raised those concerns?
Well, I certainly was not well received. As a matter of fact, there was quite a scene in the hallway. Merry Christmas. You know, I don't celebrate Christmas. I don't celebrate Christmas, and I don't think this is really right. Every time I walk by here, I feel offended.
Well, we've had this here every year.
I
Bridget,
know,
and-
but I'm fine.
All right. Based on what you're showing me here, I have to do a little more research, but I think you may have a claim under both state and federal discrimination law.
I thought so.
I'm going to look into this matter further and give you an initial assessment by Friday.
Okay.
I'll give you my recommendations in writing, and we'll look to see if we can pursue this matter for you.
Oh, thank you so much. I really appreciate your help.
And again, I'm so sorry for what you're going through.
Thank you very much. I appreciate it.
In the scenario we have just watched, a non-tenured teacher is notified that her contract will not be renewed. Many of you are probably thinking you would have made the same decision. Let's face it, the teacher in question was certainly not the ideal candidate for tenure. She had documented problems with not signing in and out of school. She had struggled with classroom management her first 2 years, although the issue did not arise in her 3rd year evaluation. Most importantly, she was thoroughly unprepared while being observed by her principal and had not bothered to read the play that she was teaching. But despite all of these problems with her performance and the limited rights available to a non-tenured teacher, Mrs. Stark is likely to have a viable claim for age discrimination based on the facts in this scenario. In order to understand why, we need to consider the essential elements of an employment discrimination claim under both state and federal law. New York State, like every state, has a strong public policy against discrimination in the workplace. In order to understand why, we need to consider the essential elements of an employment discrimination claim under both state and federal law. New York State, like every state, has a strong public policy against discrimination in the workplace. That public policy is evident in the New York State Constitution and state law, and is also enforced through federal anti-discrimination laws. This commentary will describe the scope of the state and federal anti-discrimination laws that the teacher in the preceding scenario will likely use to attempt to prove that her school district discriminated against her on the basis of her age and religion. New York State's human rights law prohibits discrimination on the basis of numerous personal characteristics. Specifically, New York provides that it shall be an unlawful discriminatory practice for an employer to refuse to hire, or to employ, or to bar, or to discharge from employment an individual, or to discriminate against an individual in compensation, or in the terms, conditions, privileges of employment because of that individual's age, race, creed, color, national origin, sexual orientation, military status, sex, disability, predisposing genetic characteristics, marital status, or domestic violence victim status. Enacted in 1945, the human rights law was the first anti-discrimination law of its kind and is similar to subsequent federal employment and disability statutes. including Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act, the Americans with Disabilities Act, and Section 504 of the Rehabilitation Act of 1973. The state human rights law is also comparable in many aspects to New York City's human rights law. Claims brought under New York State's human rights law are analytically identical to claims brought under Title VII. The state human rights law covers employers with more than 4 employees, although it does not protect individuals employed by their parents, spouse, children, nor does it protect domestic servants or individual contractors. The law provides that it's illegal for an employer to refuse to hire, employ, to bar, or to discharge from employment, or to discriminate against an individual in compensation or in terms, conditions, or privilege of employment on the basis of the protected personal characteristics enumerated in the statute. How would the teacher in the video scenario make a claim for employment discrimination? To establish what the law calls a prima facie or preliminary case of employment discrimination under the human rights law, the teacher must show that she was a member of a protected group, she was performing her job satisfactorily, she was subjected to adverse employment action, and adverse employment action occurred under circumstances giving rise to an inference of discrimination. If the teacher establishes all 4 elements of a prima facie case, then the burden shifts to the employer, the school district, to articulate a legitimate non-discriminatory reason for making the challenged employment decision. If the school district carries its burden of proffering a non-discriminatory reason for its non-renewal decision, one that's performance-based, for example, then the burden shifts back to the teacher, who would attempt to prove that the reason given by the district was a pretext, and that the real reason for the adverse employment action was unlawful discrimination based on age or religion. The Second Circuit Court of Appeals has emphasized that the initial proof burden borne by a human rights law plaintiff is minimal. Ordinarily, the mere fact that a plaintiff was replaced by someone outside the protected class will suffice for the required inference of discrimination at the prima facie stage of the analysis. In the scenario we saw, Mrs. Stark will likely be able to meet this minimal burden. She has established that she was a member of a protected class based on both her age and her religion, and was subject to an adverse employment action. In addition, while she had a number of performance issues cited in her evaluation, she is a properly certified teacher who generally had positive performance reviews and is likely to satisfy the minimal initial burden of proving her performance was satisfactory. Once Mrs. Stark has made out her prima facie case, the burden then shifts to the district to offer legitimate non-discriminatory reasons for their actions. In this case, the district should be able to easily meet this burden, since it is able to point to Mrs. Stark's problems with signing in and out and her lack of preparation in teaching Hamlet. At this stage, Mrs. Stark will need to demonstrate that the reasons given by the district are actually a pretext for discrimination. In this case, Mrs. Stark will attempt to do this in several ways. First, she will point to performance evaluations of other similarly situated employees who had a larger number of deficiencies cited in their evaluation. These other teachers, who were all younger than Mrs. Stark, all received tenure despite their poor evaluations. This is potential evidence of disparate treatment, which is often used to show that an employer's stated motives are a pretext for discrimination. The use of such evaluation data drives home the critical need for school administrators to be properly trained in the area of evaluation, and to ensure that all school administrators within a school district are consistent in how they evaluate and the standards they hold their employees to. If school administrators within a district are not consistent in their approach, they will be far more susceptible to claims of employment discrimination. Mrs. Stark will also be able to use statistical data to support her claim of pretext. The data that she has gathered indicates that 95% of teachers under the age of 40 receive tenure, while only 25% of teachers over the age of 45 receive tenure. State and federal courts have consistently recognized that employees who are subject to discrimination often do not have direct evidence of that discrimination. Rarely does an employer directly confess to discrimination. These courts have long permitted the use of circumstantial evidence, such as statistical data used here. When combined with evidence that younger teachers were held to a different standard in renewal decisions, Mrs. Stark is likely to satisfy her burden of showing that the district's stated reasons are a pretext for discrimination. The critical legal battle in discrimination cases is often a decision over whether the case should be dismissed without ever going to a jury. If a court holds that the facts are such that a reasonable jury could conclude that an employer engaged in discrimination, the case will oftentimes settle before a jury is able to reach a decision. In the scenario we saw, Ms. Stark will likely be found to have a case that should at least be considered by a jury. By contrast, Ms. Stark is likely to have insufficient evidence to prove a claim of religious discrimination based on the evidence presented in this scenario. For example, her statistical evidence does not show any pattern of offering or denying tenure to teachers based on religion, but rather only shows a pattern based on age. It is important to note, however, that the district in this scenario did make a significant mistake in only having a Christmas display and no other displays representing other religious beliefs. There is a long line of cases in which such displays have been used to demonstrate a violation of the First Amendment's Establishment Clause, which prohibits a school district from acting in a manner that appears to favor the establishment of any particular religion. Viewers are encouraged to review the materials on the Legal One website related to religion in schools. In a New Jersey case similar to the scenario we just witnessed, the employee survived an attempt to dismiss her claim of age discrimination. The court held that a reasonable jury could conclude that there was age discrimination. The court did, however, dismiss the claim of religious discrimination. This type of burden-shifting process would be followed for claims of discrimination based on any of the protected categories in state or federal law. In another case decided in 2011, an assistant principal was held to have made out a prima facie case for discrimination based on gender, pregnancy, and sexual orientation. In that case, the plaintiff was in a protected class and was qualified for her position as an assistant principal. While she was pregnant, her principal made her hire a Spanish teacher, even though such an assignment went beyond her contract. The principal did not excuse her from hallway and cafeteria duty despite her pregnancy. The principal subjected her to intense scrutiny, including scrutiny of her bathroom usage. The principal also expressed disdain for the assistant principal and prevented her from attending a teacher development course. The court observed that those facts did not necessarily create a hostile work environment, but that when viewed alongside the principal's conduct after the assistant principal returned from a 6-week maternity leave, the court held that the case could not be dismissed. The principal also forced the assistant principal to produce unnecessary doctor's notes, ordered her to leave the school without justification, and then falsified an account of her insubordination. Under the state human rights law, as in federal law, employer liability for discrimination requires that the employer had knowledge of and acquiesced in or subsequently condoned the discriminatory conduct. Employers can also be subject to vicarious liability from an actionable hostile environment created by a supervisor with immediate or successively higher authority over an employee. If an employee is the victim of harassment, an employer's vicarious liability depends on the plaintiff showing that the employer knew or should have known about the harassment, but failed to take appropriate remedial action. New York has a large body of case law in which educators have made claims of discrimination. In the recent case of Self v. Department of Education of New York City, 2 science teachers in a New York City high school claimed that they had been the victims of race discrimination when they were removed from their teaching positions. One teacher had the complaints of verbal abuse, unsatisfactory teaching performance, and corporal punishment. She refused to meet with her principal to discuss her performance issues. Several tenure charges were brought, which an arbitrator sustained. Another teacher was removed after a science curriculum reorganization based on seniority. Both teachers claimed that the adverse employment action they suffered was due to discrimination against them based on race. Their evidence consisted largely of allegedly racial comments, numerical comparison data, and other circumstantial evidence. In denying the discrimination claims in Self, the court described what an adverse employment action is for purposes of anti-discrimination law. The court stated an adverse employment action is a materially adverse change in terms and conditions of employment. To be materially adverse, a change in working conditions must be more disruptive than a mere inconvenience or an alteration of job responsibilities. Examples of such a change include termination of employment, a demotion evidenced by a decrease in wage or salary, a less distinguished title, a material loss of benefits, significantly diminished material responsibilities, or other indices unique to a particular situation. Thus, it is important to stress that the adverse employment action does not have to be termination and can often be much more subtle. Another type of discrimination claim is a claim for harassment based on one's protected characteristics. Under the state human rights law and federal laws, to prove harassment on any protected ground, an employer must prove that the employment was severe or pervasive. Severity and pervasiveness are likely to exist if the behavior is sufficiently harmful or frequent that it significantly impacts the terms and conditions of employment. By contrast, the New York City human rights law does not require employees to meet the severe or pervasive legal standard to prove a claim for liability. Severity and pervasiveness are relevant, however, when assessing damages under the New York human rights law, according to the First Department of the Appellate Division in Hernandez for case, sorry, I have to go back. Take out the according to. That last little piece. Yeah, from according to the end of that sentence. I don't want to say it. Okay. Okay. Another type of discrimination claim is a claim for harassment based on one's protected characteristics. Under the state human rights law and federal laws, to prove harassment on any protected ground, an employee must prove that the harassment was severe or pervasive. Severity and pervasiveness are likely to exist if the behavior is sufficiently harmful or frequent that it significantly impacts the terms and conditions of employment. By contrast, the New York City human rights law does not require employees to meet the severe or pervasive legal standard to prove a claim for liability. Severity and pervasiveness are relevant, however, when assessing damages under the New York human rights law. Still, another type of claim that is prohibited by the human rights law is a claim of retaliation. Retaliation claims encompassed by the statute include retaliation for having opposed any practices forbidden by the Human Rights Act, or for filing a complaint, testifying, or assisting in an anti-discrimination proceeding. Like discrimination claims, retaliation claims under the state human rights law are analyzed identically to Title VII claims. To make out a prima facie claim for retaliation, a plaintiff must show that she was engaged in protected activity, that the employer was aware of that activity, that plaintiff was thereafter subjected to an adverse employment action, and that there was a causal connection between the plaintiff's protected activity and the adverse action. If an employee proves discrimination, harassment, or retaliation in the workplace, what remedies are available to that employee? Remedies can include reinstatement to a position, removal of an unfavorable evaluation from an employee personnel file, and even damages. Compensatory damages can be awarded to employees in appropriate cases to compensate them for lost salary. If another job has been found, the salary or wages from the new job would be deducted from a compensatory damage award. In extreme cases, egregious incidents of discrimination may result in punitive damages being awarded against an employer and paid to the employee to punish the employer for action or inaction related to discrimination. The long line of employment discrimination cases offer important lessons for school districts, supervisory personnel, and other school employees. School administrators should be ever vigilant to ensure that they act quickly and responsibly to thoroughly investigate all claims of discrimination. Employers should regularly review employee practices related to hiring, evaluation, corrective action, and dismissal to ensure that these practices are not in any way discriminatory. In addition, employers should be sensitive to any patterns that may emerge, even unintentionally, that give the appearance that the employees in any protected class are subject to differential treatment. By acting in a proactive, analytical, and transparent manner, the potential for employment discrimination will be greatly reduced. Viewers are encouraged to review the materials available on the Legal One New York website for further information about employment discrimination.